Hi, my name is Chris Yukins. I'm a professor at George Washington University Law School in Washington, D.C. Welcome again to this course on anti-corruption and procurement, a course that's prepared with the support of UNOPS and the International Anti-Corruption Academy. Welcome to this module number 4 on conflicts of interest in public procurement. So let's start with the definition of a conflict of interest. According to the Organization for Economic Cooperation and Development, the OECD, a conflict of interest, and this is really focusing on a personal conflict of interest. A conflict of interest involves a conflict between the public duty and private interests of a public official, in which the public official has private capacity and interests which could improperly influence the performance of their official duties and responsibility. Again, that's a personal conflict of interest. One can also have an organizational conflict of interest, or a corporation or firm can have an organizational conflict of interest. The next definition goes to that. Conflict of interest occurs when an individual or corporation, either private or governmental, is in a position to exploit his or their own professional or official capacity in some way for personal corporate benefit. We'll be returning later again to this question of an organizational conflict of interest. The UN Convention Against Corruption, the UNCAC, does not contain a definition of a conflict of interest, but it calls for state parties to adapt, maintain, and strengthen systems that prevent conflicts of interest. State parties are to establish measures requiring public officials to make declarations regarding, among other things, their outside activities, employment, investments, assets, and substantial gifts or benefits from which a conflict of interest may result with respect to their functions as public officials. The European Union's Public Procurement Directive says a conflict of interest is a situation in which persons involved in or able to influence the procedure by which a purchaser awards a contract have a direct indirect financial, economic, or other personal interest that could jeopardize their impartiality and independence in that procedure. So you can see that the European Public Procurement Directive sweeps up both personal and organizational conflicts of interest, topics which we'll be discussing more in the subsequent slides. It's important to understand the relationship between conflicts of interest and possible corruption. A conflict of interest exists when someone could abuse his or her official position for private gain. Corruption exists, actual corruption exists when someone does abuse his or her official position for private gain. Conflicts of interest may arise at all stages in the procurement process, whenever decisions are made in procurement, and they could be influenced by private interests. That can occur in the drafting of technical specifications or during the bid evaluation process of contract award, indeed even during contract administration. The consequences of a conflict of interest are, according to international best practices, that a procuring entity generally should exclude a bidder from the tender process if the bidder has a conflict of interest. So, for example, if a bidder has an organizational conflict of interest, international best practice is to exclude that bidder, absent a special waiver, for example, from the procuring entity. As a practical matter, conflicts of interest are not always avoidable. Employees can't be faulted for having family or financial connections. Conflicts of interest may be current, or they may have existed in the past. It's not wrong or unethical to have a conflict of interest. The important thing is to have procedures to identify, prevent, and remedy conflict of interest, to mitigate the risk that conflicts of interest present. Procuring entities need to be careful about potential, actual, and perceived conflicts of interest to seek not only best value for money, but trust in government institutions. In other words, a conflict of interest raises not only issues regarding a potential performance risk, that a contractor, for example, with conflicts of interest may not perform adequately, but a conflict of interest because others may see it from the outside, taxpayers, for example, other stakeholders in the community. Conflict of interest can raise reputational risk for the procuring entity, for the government as well. So let's review here some examples of potential conflicts of interest, both personal conflicts of interest and organizational conflicts of interest. So, for example, one would be where a procuring entity, a government, awards a contract to a company in which the procurement officer holds shares. That's a personal conflict of interest on the part of the procurement officer. Another is where the Ministry of Education is awarding a contract to a company owned by the minister's brother. Again, a personal conflict of interest. What if a member of the evaluation committee has a close relative who is a member of the bidder's proposal team? It's also a potential conflict of interest, a personal conflict of interest. Another is when an external technical consultant who assists in drafting the technical specifications for a particular procurement has commercial relationships with the companies that will in fact bid for this contract opportunity. That's both a personal conflict of interest on the part of the consultant, but more importantly, this will normally be handled as an organizational conflict of interest. The idea that the technical consultant has an organizational conflict of interest where the company for which he works has a tie to other companies that may bid for the contract, and therefore the product that the company is delivering, the technical advice that the company is bidding, could be tarred by an organizational conflict of interest. Finally, when a procurement officer awards a contract and leaves office to start working for that contractor, that can create a personal conflict of interest for that procurement officer, but again, it can also create an organizational conflict of interest. The company that hires the former procurement officer, if the company that hires the procurement officer under international best practices gains an unfair competitive advantage, that may constitute an organizational conflict of interest that would exclude that company from bidding for the contract at issue. It's important to stress that in practice, it can be very difficult to discern whether or not a conflict of interest exists. The parties involved may try to hide the conflict of interest, but even if they don't, it can be very difficult to untangle. The chart here on this slide shows a complex situation, for example, where there's a series of corporate entities that lay between the procuring officer and the procuring entity. Corporate entities which may give the procurement officer or a minister, for example, a personal interest in the outcome of the contract. It may be that the procuring officer or the minister is using shell companies to try to hide their interest. If that's the case, new laws, new requirements that the beneficial owners of the bidders be disclosed, they become more and more important. And that's an emerging trend internationally, a requirement that the beneficial owners, say the shareholders in a corporation that is bidding for a public contract, be disclosed. It's an important emerging anti-corruption device internationally. So let's talk about some of the tools that can be used to minimize conflicts of interest. An important starting point is that the law, the legislation, or the regulations set forth clear definitions of conflict of interest so that those who are dealing with conflicts of interest, the individuals involved or the corporations involved, can clearly mold their practices or mold their behavior in order to conform with the law. The rules on the functions and positions to be held by procuring officials regarding the revolving door, the movement from procuring officials into the private sector, which is sometimes called the revolving door, those should also be clearly defined. There should be a bar against accepting other paid positions while holding office. That's a standard as an international practice, a standard ethical rule constraining procuring officials. There should be a prohibition against holding ownership stakes in companies while doing business with the procuring entity or the government. There should be a cooling down period. This is oftentimes used especially for senior officials. After leaving government, a cooling down period before the public official can take positions with a company with which the procuring entity or government does business. This is so that the official who's left government can't trade on his influence or his contacts within the government. There are possible disadvantages to these kinds of rules. Individuals may not decide to work for the government because they feel that they don't want to be constrained in the future by these conflict of interest rules. Or there could be a lack of knowledge sharing between the public and private sector. The members of the private sector may not want to share information or knowledge with the public sector if they feel that those might trigger conflicts of interest that could, for example, disqualify them in future procurement. So there's a trade-off that has to do with setting up these rules or these tools to address conflicts of interest in procurement. Let's talk through some of the other tools to minimize conflicts of interest. There should be a code of conduct for all public employees to build their awareness. There should be explanations of potential consequences for violations, and what's very often useful is actually examples of conflicts of interest that have arisen in the past. Employees should be called upon to declare any potential conflicts of interest. For example, any procuring officer preparing tender documents, evaluating tenders, or conducting negotiations should declare any actual potential or perceived conflict of interest as soon as he or she becomes aware of the potential conflict. Again, this is important to ensure the integrity, ensure the perceived legitimacy of the procurement process. Some countries require procurement officials to declare their assets, their income from all sources, their sources of employment, their directorships, their unpaid board memberships, or participations in organizations, investments, etc. All different types of entangling involvements with outside corporations or outside organizations that could or might be perceived to create a conflict of interest. There should be restrictions on individuals sharing conflicts of interest. So, for example, an individual should refrain from taking part in the process, or should abstain from voting on decisions, or restricting access to information if that individual has a conflict of interest. For example, a tie with a particular corporation that's bidding on the procurement. Further tools to minimize conflicts of interest include such things as replacing or removing individuals from involvement in a particular procurement. If that's not possible, the procuring entity might consider entrusting an independent third party to monitor the procurement. One could ask the official to relinquish the personal or private interest by, for example, relinquishing shares in a private company that might be bidding on the procurement. The relationship between the procuring official and the agency might be terminated. The official might be asked to resign, or might resign of his own accord if the conflict of interest can't be resolved in other ways. What's important, what really facilitates this entire process, is to have a conflict of interest adjudicator, an independent third party who rules on whether or not a conflict of interest. For example, in the U.S. government, that's very oftentimes an ethics officer who's assigned to a particular agency. And that independent third party will advise on the appropriate next steps to take based on existing and published rules. So, as we noted before, having a conflict of interest isn't always avoidable or necessarily unethical. The important thing is to identify it and to manage it. And again, both manage it from the standpoint of managing any performance risk that might create, and importantly, from the perspective of managing it so we address any reputational risk that the conflict of interest could create for the procuring entity, for the broader government. That calls for transparency throughout the procurement process, which assists in spotting potential conflicts of interest. The more transparent, the more open a procurement process it is, the more likely it is that conflicts of interest will be recognized. For example, tender requirements should be specified and pre-disclosed. Once the tender requirements are well-defined and public, it's easier to identify those vendors that might have a conflict of interest. The procuring entity should keep a comprehensive procurement record so the procuring entity can identify potential conflicts of interest. There could be declarations. Bidders could be asked to explicitly confirm an absence of a conflict of interest. That could be part of the bidding process. And disclosure. Bidders, including their board members, can be asked to disclose any ownership shares in companies, including the names and addresses of those who might pose a potential conflict of interest. So let's close out here by talking about an organizational conflict of interest. The organizational conflicts of interest that can be presented, for example, by consulting firms. Very often, procuring entities will rely on a third party for special technical expertise, for example, legal or technical advice in drafting tender documents, including technical specifications, or ask for outside advice on legal and technical evaluations of bids. When that happens, the procuring entity needs to make sure that it's receiving objective advice, that it's receiving advice from a company or an individual that does not have an organizational conflict of interest. This could mean obliging the consulting firm, for example, to report any conflicts of interest. It can also mean if consulting firms, specific consulting firms, might have ties to predictable bidders, it can mean barring consulting firms, saying that they're excluded from participating in particular procurements. An example is where an engineering company is assisted in drafting technical specifications for a tender and subsequently bids for this contract opportunity. That's a clear organizational conflict of interest. And this is such a common problem. It rises again and again in procurement. In fact, it doesn't just appear in anti-corruption laws, it often appears in international trade agreements. The concern is that those outside consultants who have particular inside line on helping shape future procurements, they may create discrimination in the procurement that in effect violates anti-discrimination requirements in international trade agreements. So international trade agreements oftentimes also bar this type of organizational conflict of interest. The law regarding organizational conflict of interest continues to evolve around the world. It's an emerging best practice, but it's an important element of anti-corruption to be aware of. I hope you've enjoyed this module on potential conflicts of interest in procurement. Thank you again for joining our program on anti-corruption in procurement.